My name is Alicia Slook. I am with the Loudoun chapter of the League of Women Voters, and I'd like to welcome all of you and thank you for coming out tonight. Beautiful nights. You're giving up an hour of sunshine out there, but we're grateful you want to spend your time with us because we have an excellent panel who's going to talk about some extremely important issues in our community, particularly the 3 constitutional amendments we'll be facing on our November ballot. So I'm going to make a few introductions and then we're going to get on with our program. First of all, I'd like to welcome our president, Joanne McAlpine. She's going to say a word or two.
Hello, thank you for coming. My name is Joanne. I am the president of the League of Women Voters of Loudoun County. And I first want to thank Lorraine Moffat, who is with the Loudoun County Public Library, who really helped us get this program going. And I don't think we could have done it without you. Thank you very much. I also want to thank the Loudoun League's Education Committee, and her fearless leader, Linda Mangiaroni, who was the chair of this. This education series we used to have, but COVID happened, and so we're just starting to bring it back again. So I hope you'll keep an eye out for it more. So to tell you a little bit about the League, we like to empower voters and defend democracy. We defend democracy by empowering voters. We empower voters by helping them to register to vote, to tell others to go out and vote, and to educate them on issues and what to expect in the ballot box. So they are informed voters when they do go out to vote. So if you are interested in joining the League, we have a sign-up sheet, or you can look at the brochure. And if you're interested, it'll be on the table over there. So thank you very much, and Alicia, back to you.
Thank you, and I don't want to be remiss in thanking our partners here at Cascades Library, the staff who helped facilitate getting us set up. What a beautiful facility. Grateful to you, Lorraine, and to the people who made this happen for us tonight. So we are going to get started. I would ask, if possible, if you don't need to keep your phone on, if you would kindly mute it as a courtesy to our speakers. The way we're going to run the program is I'm going to briefly introduce our speakers to you. Then they are going to be given approximately a 20-minute segment on the constitutional amendment that's in their wheelhouse, and they're going to talk about that. After all the panelists have finished talking, then we will have question and answer. So kindly, if you have a question, try and hold it in your head until the conclusion of the panelists speaking, and we will go from there. Okay, so I'm going to start by introducing our panelists. We have Lisa Coteen-Gorchik. I am going to give abbreviated biographies, but these people have very illustrious careers and resumes. She is the co-leader of the Voting and Elections Issues Group of the League of Women Voters of Virginia. That issues group analyzes and prepares the state league's policies regarding voting and elections, and then advocates before the General Assembly during its session each year. Outside of her work for the League, she has worked in elections since 2012. First as an observer and voter protection advocate. After moving to Fauquier County, she served as an officer of elections. Shout out to all of us who are officers of elections. And assistant chief elections officer. She was first appointed to the Fauquier County Electoral Board in 2023, where she still serves. She is a retired international trade lawyer who negotiated trade agreements on behalf of the United States Department of Commerce. That's Lisa. Next up, we have Irina von Breda, who is a retired physician who practiced in the Northern Virginia area for 36 years. She's a naturalized American citizen and from a childhood from the Netherlands, wonderful country. She has become an active volunteer for several causes, but has dedicated the largest share of her time to voter registration. She serves on the League of Women Voters of Virginia Voting and Elections Interest Group, helping to advocate for protection of and expansion of voter rights before the legislature in Richmond. She works countless festivals, colleges, tabling events, registering voters. Best estimate, these efforts with the participation of hundreds of volunteers have resulted in over 19,000 people registered to vote in Fairfax County over a 4-year period. And regrettably, I did not note the exact name of this, but she has just been awarded a very prestigious award by George Mason University in honor of her service to the community regarding voter registration. I think it's called the John Wood Award? Jack Wood. Okay, I was pretty close. Congratulations. Next up, I have Han. Han is the campaign manager with Virginians for Reproductive Freedom. They have been working at political campaigns in Virginia and across the country for the last 10 years, hard to believe, looking out like young, with the goal of electing progressive leaders who will serve as reproductive rights champions. When Han is not engaging in political work, they enjoy traveling, cooking, spending time with their partner and dog, Ella, who no doubt is adorable. Thank you, Han. And last but certainly not least is Lee Laurinello, who is the president of the Board for Equality Loudoun, the county's first and largest LGBTQ+ advocacy organization. With more than 20 years of experience in HIV and LGBTQ+ issues and advocacy, she is on the front for all of this. She is deeply committed to the well-being of Loudoun's community and is honored to work alongside the passionate advocates who make the Equality Loudoun team so impactful. Thank you all for being here. So without further ado, I'm going to turn it over to Lisa. And we're going to turn the lights down.
Thank you very much, Alicia, and it's really great to be with all of you tonight. Arena and I are sort of a team on this, and I will take the first part and then she will follow up. First, we're going to start with how to amend the Virginia Constitution. But before, maybe I should go back. How many of you are league members and how many are members of the public otherwise? Raise your hand if you're a member of the league. That's a pretty good number. So, the league today has been up in front of you and you can see that information. So we'll move ahead to amending the Virginia Constitution. It's a somewhat intriguing method. I think of it as a sandwich. In the first year, in one year, a particular proposed amendment, and it can be any of these or any other amendment that you might think of, including this most recent referendum. The proposed amendment must pass both the Virginia Senate and the House of Delegates in a session of the General Assembly. Then there is, following that, there must be a general election of the Virginia House of Delegates. And in the following General Assembly session, the identical wording for the proposed amendment must again pass both chambers of the General Assembly, the Senate and the House of Delegates. That is in the wintertime. In the following general election in November, the ballot question that has passed the General Assembly will be on the ballot for the voters. And that's the way it works. It's complicated, but it's also pretty simple. The sandwich is identical language passes, and in between you have that general election. Next slide, please. Arena and I are going to be talking about the proposed amendment to the Constitution providing for the right to vote. Currently, under the Constitution of Virginia, in order to vote, you must be a citizen of the United States, a citizen of Virginia, at least 18 years of age before the next general election, and you must not have a prior felony conviction unless the governor has restored the right to vote after you were released from incarceration. And you may not have been adjudicated as mentally incompetent. That is what the current Constitution says. The proposed amendment would do three things. It would automatically restore the right to vote upon release from incarceration for a felony conviction. It's automatic. The person who's been released doesn't have to do anything to apply and request restoration of rights, but simply can register to vote. And then it also requires a specific determination by a court when someone is being adjudicated as to their capacity, whether or not that person has the capacity to understand the act of voting. Now, I said there were three things. The third thing is that the language of this proposed amendment refers to the fundamental right to vote. And that is also another key aspect that Virginians would right to vote is fundamental. Next slide. Okay, I'm going to talk about the adjudications of mental competence first, because we're going to be spending quite a lot of time talking about felony disenfranchisement. In guardianship adjudications, too often courts have made blanket assessments and failed to make determinations of exactly what rights a person loses when assigned a guardian, such as the right to vote and the right to marry, even though the law already requires that such determinations be made. The concept of guardianship was introduced in Virginia in the 1980s. Before then, adults who were considered to be incompetent had decisions made by a committee. It's a committee, but it's pronounced committee. The guardianship process became more complex and more privatized over time, with private individuals serving as guardians for their family members. And old-fashioned judges who were used to the original system have found this judicial process to be overwhelming, and they have tended to truncate it and bring it back to their old rubber stamp. This amendment would compel the courts to treat these citizens appropriately and make a specific individual determination of their capacity. Now, realize that many adults who need assistance in some aspects of their lives are fully aware of what's going on in the world. Not only are they capable of voting, they might even be passionate about public affairs. And I'll give you an example. Arena's nephew, who is brilliant in many ways, cannot read numbers or understand numbers. He needs a guardian in order to help him manage his financial affairs. But he understands voting, he cares deeply about it, and he should never be deprived of the right to vote, simply because he has a problem with numbers. Similarly, we had personal experiences with a mother whose daughter has Down syndrome and was pretty much living independently and had a job and had voted and went to a polling place one day and was told she was no longer registered to vote. Why? Because her mother and she had agreed that her basic trusting nature made her vulnerable to scammers. And so she needed someone to help her with her financial affairs again. Also, this proposed amendment would modernize the terminology that is used. No longer do the courts consider mental competence, they consider capacity. This situation is currently affecting about 12,000 adults in Virginia. On the next slide, we are going to get into this issue of felon disenfranchisement in Virginia. The whole concept of removing rights from citizens it's an ancient one, it goes back to Rome, and it revolves around the notion that citizens with rights, that would almost always be a male, and in the former British colonies, white males, if those people commit heinous crimes such as treason or murder, they should be removed from civil society. Now, after the Civil War, with ratification of the 13th, 14th, and 15th Amendments, enslaved black men received emancipation from slavery, citizenship and protections, and the right to vote. During Reconstruction, black men voted and were elected to public office in the South. To be readmitted to the Union, however, Virginia had to accept certain conditions. And those, the Readmission Act of 1870 gave us the first condition of readmission, that Virginia's Constitution would never deprive any citizen or class of citizens of the right to vote, except as punishment for such crimes as are now felonies at common law. Reconstruction ended in 1877, and by 1890, civil rights enforcement had pretty much fallen away completely, and white men took back their power. They found end-arounds that were facially neutral. They did not refer to race. And this led to the Constitution of 1902. The Constitution of 1902 deliberately instituted not only poll taxes and literacy tests to circumvent the Readmission Act, its drafters added to the felonies of common law that were contained in the Readmission Act. And they thought that they added to them because they thought that those particular crimes were most likely committed by black men. And I want you to take a look here at some language. The entire, as it were, the entire report of the proceedings for creation of the Constitution by its commission was essentially transcribed. And a very prominent gentleman by the name of Carter Glass, who later became a United States Senator and at one point was Secretary of the Treasury, said what you can read here, and I will quote just a little of it and say, the plan of popular suffrage will eliminate the darky as a political factor in less than 5 years, so that in no single county of the Commonwealth will there be the least concern felt for the complete supremacy of the white race in the affairs of government. And furthermore, at a later point in the debate, he said, discrimination, why? That is precisely what we propose. That exactly is what this convention was elected for, to discriminate to the very extremity of permissible action under the limitation of the federal Constitution. As a result of this particular Constitution, which was never ratified by the people, it was simply adopted. 90%, over 90% of black men lost the right to vote. Now there were federal laws. The Civil and Voting Rights Acts of 1964 and 65 addressed many racially motivated inequities, but not felon disenfranchisement. Virginia's Constitution was rewritten by a commission and ratified in 1971. The chief drafter, a UVA professor named A.E. Dick Howard, could not explain exactly why the felonies were never addressed in that Constitution. As one critic said, and listen carefully, the absence of racial evidence is not evidence of racial absence. This slide about recent governor's actions demonstrates very clearly that restoration is completely at the whim of the governor. The governor has total discretion. There are no criteria. It can be completely arbitrary. Some of the governors began more recently to shorten the times for waiting after release from incarceration, and simplifying the application forms, and even automating the process. But those advancements could be and were reversed. The most recent governor, before Governor Spanberger, reversed practice. He resumed individual decisions with no criteria reported or announced. In 4 years, he restored the rights to 9,563 citizens. And he would send denials, or rather his Secretary of the Commonwealth would send denials with no explanation for why the application had been denied. And it would simply say, you may apply again in a year. But no one knew what barriers they would have to surmount in order to successfully receive their rights restored. And now I will turn this over to Arena.
Thank you, Lisa. I will be brief because we are going to run out of time otherwise. I just wanted to point out very quickly that scale of difference between the number of people with the rights restored under the next prior governor, Northam, versus the Youngkin administration. You see that there was, we're down to 10%, less than 10%, which meant that there are an awful lot of people who did not get their rights back, who would have otherwise been potentially qualified had this constitutional amendment been passed, and they would have automatically gotten their rights back. Nationwide, there are over 4 million people who have been deprived of the right to vote. This is a highly discriminatory, and because of the history that you've heard from Lisa about what happened in Virginia, it happened in other states as well, these laws were written and targeted specifically for minority populations. That's not an accident, as you heard, it was explicit. Every state is allowed to make its own decision as to how to deal with this. And there are a number of states, Vermont, Maine, and the District of Columbia and Puerto Rico, that never disenfranchise someone because of a felony conviction, which means that our sister league over in DC, they actually go register people to vote in the jail for whatever they're committed for, whatever crime, felony, misdemeanor, whatever, and those people are actually allowed to vote. 23 states make restoration automatically. This is definitely the mainstream position. Virginia has been one of the outliers and one of the worst offenders in terms of being stingy, straining that quality of mercy very finely when it comes to restoring rights. In Virginia, over 300,000 people are ineligible. This is data as of 2022. 300,000 people ineligible to vote due to prior conviction. That's 5% of all eligible voters. You want to talk about a close election and does this make a difference? You do the math, 5% of all voters, it can make a big difference. The rate is even more appalling when you look at the effect on the minority population, where it's over 12%. More than 1 in 10 of every Black potential voter in the state of Virginia cannot vote because of these laws with the history that you've heard from Lisa. This is just a map to give you an idea as to where the darker the state, the more discriminatory in terms of restoring people's rights. And you can see there's an awful lot that are clustered in the South, again, because of the similar history to what Virginia has done. Okay, why do we think it's very important, we meaning the League of Women Voters, that this right to vote amendment pass? Well, the right to vote is fundamental and foundational to all of the rest of our rights. Without your right to vote, the rest of your rights are completely expendable. And you achieve what civic power we have in this country through your right to vote. When people have had involvement with the justice system, if they've had prior convictions, they are still citizens, they are still paying their taxes. All of the rights and other obligations that are incumbent upon someone as a citizen in the community still exist. Why should they be singled out to lose the right to vote? Very important to know that there is evidence that shows that when people have their rights restored, it restores their sense of belonging to a community, it increases their civic engagement, and their sense of civic responsibility. So this really is actually extremely good to helping us improve the community safety, because restoring voting rights has been shown to lower the rate of recidivism. So there's both a moral and a common sense imperative as to why we should be restoring people's right to vote. We do this work in our leagues throughout the state, go to different places where we are trying to find the people who have been affected and telling them now with Governor Spanberger, who has gone back to the Northam model of restoring anybody who asks. We are trying to find people, let them know that they can apply to get their rights back, and they should do it now because that means they will be able to vote on this very important constitutional amendment in November. And this is a picture of me and one of our other volunteers with a gentleman that we discovered at a homeless shelter who thought his right to vote had been lost permanently. He had been told, don't bother to apply. We went through the process with him, found out that his rights were restored, and then had him register to vote. There are lots of venues where you can reach these folks. So if you're interested in doing this work, please come and speak to me afterwards. I would just like to say we have on our table over there a little business card that we hand out at our voter registration events. It says, "Have you lost your right to vote?" It's a QR code that goes directly to the website from the state that will allow people to find out, have their rights already been restored? And if not, to go ahead and do that application. Feel free to take some with you. They're over there on the table, and hand them out. Churches, libraries, barbershops, great, I see a number of men here. The convicted population is obviously skewed much higher percentage for men, so we love getting these into barbershops where people are likely to find them. I think, how are we doing on time? Because
I can give you 2 or 3 more minutes.
that's all it's going to take. So we've already kind of pointed out what this means for the formerly incarcerated. This is no longer something they have to go quite literally on bended knee to the governor to ask their rights back. It will be automatically. As soon as they complete their period of incarceration, they will have their rights back. They will still need to register to vote. So that is something that we need to educate the community about. There's no waiting period. They don't have to pay fees. They don't have to pay restitution. This is something that happened in Florida, where the state as a whole voted to do something very similar, automatic restoration of rights. And the subsequent legislature came in and said, oh, not so quickly. We're going to tag on, you have to pay fees where you can't even find what you're supposed to pay. You have to pay restitution. We're not going to let that happen in Virginia if we can pass this amendment. Lisa did a very nice explanation as to what it means for people like my nephew, who could have potentially lost his rights to vote simply because he was under guardianship. We'll be able to restore rights to those folks as well. And obviously, what it means to all of us as Virginians is that we can join the 21st century and take a little bit of pride in the fact that we are taking a much more appropriately empathetic, understanding, and basically moral position about the right to vote. So we're hoping that you will share our enthusiasm for this amendment and tell your friends and family this is not an election to skip. People need to make sure that they are voting, and don't underestimate. I think a lot of people have personal experiences about marriage equality and reproductive rights. They have feelings about it. They're fairly aware of these because they've been hot button issues for a long time. Disenfranchisement of people with felony convictions has not been a hot button topic. I would venture to guess that many of you may be hearing about this for the first time, possibly. So we need to really do that education. Thank you very much, and I'm going to...
Hi all, my name is Han Jones. I'm the campaign manager for Virginians for Reproductive Freedom. We're the coalition that's leading the work for the Reproductive Freedom Amendment. I want to just start by saying thank you so much to the League of Women Voters for inviting me to be here today. I want to thank all of you for being here today. I know it's really pretty weather and you're in a dark room watching presentations about politics, so thank you so much for being here. And I also just wanted to take a second and recognize the moment that we're in here as Virginians. I don't know if y'all watch the news very much, but it can be a real bummer. And I know that I'm really excited to be in a room full of engaged people like you, sitting up here with people who are trying to do the work to end Jim Crow and the codification of homophobia in our Constitution, and make Virginia the state we all know it can be. So I just wanted to start by saying I'm so happy and hopeful to be here with you all today. So to talk a little bit about who we are. So I'm from Virginians for Reproductive Freedom. We're a coalition of Virginia families, doctors, nurses, and healthcare organizations working to ensure Virginians can make reproductive healthcare decisions free from government interference. We are a broad coalition. You can see just a few of the organizations that we partner with, including we have League of Women Voters around the side. We also have new partners that we haven't even added to this yet because we've been busy, including Catholics for Choice and a number of youth groups, and we are just constantly growing and joining hands with more and more of our partners to make sure that we're getting this work done together. So what is our ballot measure? I'm sure many of you have seen the many ballot measures passed across the country with regards to reproductive freedom. Ours is a little different than a lot of those. Our ballot measure will amend the Virginia State Constitution to protect Virginians' freedoms to make personal decisions about prenatal care, childbirth, postpartum care, birth control, abortion, miscarriage management, and fertility care. That is a broad spectrum of reproductive health care that is protected by this ballot measure. In addition, it will protect doctors, nurses, and patients from being criminally punished for these decisions. And our amendment does allow restrictions on abortion during the 3rd trimester, except when the patient's health is at risk or the pregnancy cannot survive. So that is the general overview of what our amendment does. I want to talk a little bit about why this matters. I think it's easy when we're sitting up here and we're talking about all these different amendments that will actually change Virginia's constitution. Ours will change Virginia's constitution to codify what we currently have. So I want to talk about why that is in so many ways so important to maintain this access. So the first piece is that, and this looks very similar to the restorations of rights map we just looked at, the restrictions in the South on abortion are extreme. We see all of those red states on this map have abortion bans at 6 weeks or below. That is before most people know that they are pregnant. North Carolina and Virginia are the only 2 states that have abortion access after 6 weeks. North Carolina's cuts off at roughly 12 weeks, but it's a little complicated. And the other important thing to note about all of these states is even if you need an abortion before 6 weeks, there is a 72-hour waiting period to receive an abortion in all of these states. So what that means is that if a person needs health care, they have to wait to get it. So if you are, for example, from a banned state like Florida, and you need to access reproductive health care, and you have children, which, for the record, a huge amount of people seeking abortion care already have children at home. This means that you have to potentially take off time from your work, travel across state lines, find childcare, to be in a state other than your own for over 72 hours in order to receive the care that you need. In Virginia, we do not have those waiting periods, making Virginia a real access point for Southern patients. As I talked about, Virginia's had the largest increase in total abortions in any U.S. state between 2023 and 2024 as a result of the passage of these abortion bans. A lot of this has actually been because of the increased restrictions in Florida that we saw after their constitutional amendment, which required 60% to pass, did not succeed. Florida still has a 6-week abortion ban, which is leading to a large amount of Floridians needing to leave their state for care. So I'm going to go through this very, very, very quickly because our friends who are working on the restoration of rights already talked about it in a lot of detail. As you can see, we've made it through a lot of steps. The reason I want to just take a second and talk about this is because, as we said, we needed to win elections. We needed reproductive freedom champions to be in these seats to vote for this amendment for us to be able to be where we are now. What that means is that we know reproductive rights is popular in Virginia. We've watched people vote on it when they're voting on their legislators over and over again. We know reproductive health care is a turnout issue for Virginians. We know it's a persuasion issue for Virginians. We actually know that a lot of Republicans are with us on this issue, and reproductive freedom is more popular than any politician in the entire state. This is the ballot language that everyone will see when they go in to vote on November 3rd. I'm just going to take a second to read this, because this is what Virginians will have the opportunity to vote on. Should the Constitution of Virginia be amended to 1. Protect the freedom to make personal decisions about prenatal care, childbirth, postpartum care, birth control, abortion, miscarriage management, and fertility care. 2. Protect doctors, nurses, and patients from being punished for these decisions. And 3. Allow for restrictions on access to abortion during the 3rd trimester of pregnancy, except when the patient's health is at risk or the pregnancy cannot survive. This is what Virginians will see when they go in to vote, and we expect that a good chunk of them are going to vote yes. So just to talk a little bit about the campaign we're running. Our core messaging is what we know is true, what we know resonates with Virginians. This amendment is going to put patients in control, and it doesn't punish providers. Every pregnancy we know is unique and has unique needs. We're seeing throughout the South in real time as people's pregnancy needs are not being able to be addressed, and women are dying in real time, all the time, across the South and in banned states. This is going to allow our patients to make personal reproductive health care decisions and protect medical professionals from criminal punishment or fear of criminal punishment, so they can always make the choices that are best for their patients. Second, this protects a range of reproductive freedoms. Like I said, this is not just abortion. This is about people being able to make decisions about when to start a family, how to start a family, and being able to get the care they need to start that family. And finally, this stops government interference. This amendment will stop Virginia politicians from taking away our freedom to make our own healthcare decisions, as has happened elsewhere in the South and in many states across the country. We have watched these anti-abortion politicians pass abortion bans, and we have watched people suffer because of them. We are going to stop that from happening here in Virginia. And we know Virginia politicians are trying to do it too. They have many times tried to pass an abortion ban here in Virginia. I'm sure many of us remember the 2023 elections when they actively campaigned on trying to bring an abortion ban to Virginia. This will prevent that long term. So we have conducted polling and legal research. We've worked with our legislators to refer the amendment. We've run a strong statewide campaign urging voters to vote yes, and we are going to vote yes to pass the amendment on November 3rd, 2026. We always say bye because there are 45 days of early voting in Virginia, so we have 45 election days minus Sundays that we know we can move people to vote for this amendment. Our main priorities as we're going into this spring, we have just onboarded our communications director and our organizing director. We did a bunch of legislative thank you letter writing to thank our legislators for all the work that they've done. We've had op-eds placed across the Commonwealth. I don't know if any of you have seen any of those, but we've had some wonderful healthcare providers write about why they need to be able to see their patients without politicians or lawyers being involved in that discussion. We've had wonderful op-eds placed by people who have needed abortion care and been able to access that care and how that helped their family. We've had an op-ed by a woman who was able to start her family through fertility treatment because she was able to access that type of care. So we know that storytellers are a great way to highlight all of these issues. We know that the political is always going to be the political, but when you hear from a person who needed this care, who was able to start their family because of this care, who was able to remain healthy because of this care, it really moves people. And finally, we are moving towards a large-scale campaign launch on May 16th. So you will see here, we are having a large-scale campaign launch on May 16th. It is in Richmond, and I know how far that is for y'all because I just drove here from Richmond. And I know that with traffic, it can be even longer. But we know how important it is for this to be a big moment. We know we are the majority. People who support reproductive freedom are the majority in America, in Virginia. And we know that the anti-abortion extremists love to show up. So we need to show up just as strong. We need to show the support of this amendment. So we would love for anyone here to be able to join us. We do have some buses going down for the launch, not directly from Loudoun County because buses are expensive. But, and I know neither of these things are that close to, I think like 45 minutes for either, but we do have buses leaving from Arlington or Woodbridge. So if you would like to join and you need transportation, if you scan that QR code and you just mark that you need transportation, we will reach out to you about how you can come to Richmond and join us for our launch moment. We are going to have a big rally. We are going to hear from a lot of affected Virginians, what we call storytellers. We're going to have providers there to talk about why this matters so much, in addition to doulas and local care providers to talk about why this moment is so important. We are so excited to be part of this movement. We know that there have been a number of states that have passed these amendments across the country, including states that aren't generally thought of as progressive bastions, such as, like Kansas, and Missouri. So we feel very confident that we are going to be able to be successful. But what we need to be able to do is work with all the Virginians on the ground, work with people like you, to get out the word, to be talking about this amendment, making sure people know, and making sure people are ready to show up on November 3rd and vote yes. So please scan our campaign launch if you haven't already and you want to join. We also have a website that you can join us at, Virginians for Reproductive Freedom. The other thing I'll say is that we are always looking for people who want to share the reproductive healthcare stories. And if you're sitting there like, I don't think I have a reproductive healthcare story, you might. That doesn't mean that everyone we to work with has had an abortion. Some people use birth control and it allowed them to later on have the family they want. They used fertility treatment. They needed prenatal care. They needed postpartum care. All of that is part of this amendment, and demystifying that care by talking about it with our families, friends, neighbors is how we're going to not just win this November, but continue to change the culture that has been so strongly anti-abortion that Roe v. Wade was able to be overturned and that all of these states have had abortion bans. We need to change this and make sure that people understand that reproductive health care is health care and that people should be able to access that health care and make decisions with their doctors and nurses without politicians being involved. Thank you so much, and we hope we'll see you on the campaign.
I do a lot of presentations, and I would say that having 3 laptops in a row work is pretty darn impressive. Good for all of us. So hi everyone, I'm Lee. I am the board chair for Equality Loudoun. Thank you so much for having me. I want to shout out that the League of Women Voters of Loudoun is one of our Equality Allies, which is one of our signature programs where we have businesses and nonprofits and organizations and faith entities that have allied themselves to the LGBTQ community in Loudoun County. And so you can do searches on that and go to a salon that's affirming and lots of other opportunities there. So just a shout out to our allies who we love to participate with. So I'm going to be talking about marriage equality, but I wanted to start just mentioning our mission at Equality Loudoun. We are a nonprofit organization, and our goals are to promote inclusion through that Allies program and other partnerships, to build community and to provide education to support LGBTQ equality in Loudoun County. And we would love to envision a county where LGBTQ people and all marginalized groups, including some of the others we've talked about today, are fully embraced by active allies and can live safely and openly. So those are our mission and vision statements. We do have rack cards spread out in a lovely fan on the table over there. So if you want to know more about what we do, you're welcome to access those or visit our website. I'll pop up at the very end. But our work is mostly in the sort of community building world. We are, our goal this year is to open a community space that we can invite our allies and our community members into in order to build that community. So I'm going to spend, because some of these slides are going to be things that we've talked about already about the how, I'm going to spend maybe a little bit more time on history than I normally would in a talk like this, just to lay the framework a little bit more. And obviously this starts in 1996, but the equal rights for LGBTQ folks goes back probably also to ancient Rome, I would imagine, if not before. And all of this that we're going to talk about today is kind of in the shadow of interracial marriage, Loving v. Virginia in 1967. So a lot of this kind of falls out from that decision and the work that was done in the civil rights movement. So the first thing I'll start with is 1996. Seems like jumping ahead quite a bit, but a lot of the activity in the legislature and the courts has been since the late 90s. So in 1996 is when the US Congress passed the Defense of Marriage Act. DOMA is what it was called, if you remember that, for many years. This defined the union, defined marriage as the union of one man and one woman. It allowed states to refuse to recognize same-sex marriages, even if they were granted under other jurisdictions, and it prevented same-sex couples from collecting federal benefits. So that was the law of the land in 1996, signed into law by, I believe, Bill Clinton at the time. So between 1994 and 2012, when this was sort of in place and everyone was aware of it, 30 states decided 34 measures to define marriage as between a man and a woman. Even though the feds were already saying it, states were also passing these bans on same-sex marriage. So of those measures, 31 of them were approved and 3 were defeated. And one of the ones that was approved was ours, which passed in 2006, the Marshall-Newman Amendment, which means it also went through the two legislative votes with the election in between process, like all the amendments we're going to talk about today. And so the Marshall-Newman Amendment, not that long ago when you really think about it, I'm still of the mind where like 1990s were, 10 years ago. I've still got that vibe, I know a lot of us do. So 2006, 20 years ago, which is upsetting to say out loud. And this defined the specific language. I have the actual language, which probably won't read, but I have it here if you are interested, that marriage was solely between one man and one woman, and it bans recognition of any legal status, quote, approximating the design, quality, significance, or effect of marriage. And this passed with 57% of voters in November of 2006. And that was around the time when things started to turn the other way. So we had sodomy laws overturned in the early 2000s. We started to see more advocacy, more visibility among LGBTQ folks, which means that the way I kind of explain it to people when they ask, how did this all happen so fast, is basically, I'll put my own spin on it, is that it's hard to hate up close. And the more folks felt comfortable coming out, the more people knew someone who. And that made it a lot easier for folks to, if not embrace, at least start opening up to the idea of LGBTQ folks living in our communities, living in our families. So some of the cases that then went into play, in 2013, there was a case, and I've completely forgotten what state it was. I want to say Minnesota, but I don't want to be misquoted, so I'm not sure which state it was. But essentially, a surviving same-sex spouse that was recognized in one state was denied federal benefits when their spouse passed. And this went all the way up to the Supreme Court, and ultimately, in the Windsor decision, it basically struck down the Defense of Marriage Act, DOMA, because it violated the Fifth Amendment. So the issue there, why wasn't that the final word on the case, was because it only affected federal benefits. That was the language of the policy, so of the decision. So it only changed that surviving spouses could get federal benefits, but it didn't really change all the other laws and the state bans. I shout out Bostock v. Schaefer because it was here in Virginia, the Fourth Circuit Court, and essentially in 2014, this came from a same-sex couple in Norfolk, and at the time, Attorney General Herring opted not to defend the Marshall-Newman Amendment standing. So the state basically said, we don't want to defend this amendment, and so I think it was the AG in Norfolk who ended up being the person who advocated on behalf of the amendment. And the two courts that saw it, ending with the Fourth Circuit, made the decision that the ban was unconstitutional. So that was Virginia moving in that direction. They put it to the Supreme Court, and the Supreme Court said no thank you. So it didn't actually make its way up to SCOTUS at the time. But when the dominoes truly fell, and I remember in my day job, I work in healthcare, and I worked in HIV for 15 years, and I was working in HIV work in 2015, and I remember the moment we were all standing around and heard the results of the Obergefell decision. And so that is the marriage equality decision. It was a challenge to state bans. It was actually several different cases kind of conglomerated into one. And the Supreme Court found that the same-sex marriage bans in states were unconstitutional under the 14th Amendment due process and equal protection clauses. So that overrode every ban in every state of marriage equality. So that's been the law of the land. In 2022, Congress passed the Respect for Marriage Act, and that basically fully repeals the DOMA, from earlier, and it has a federal requirement that all states have to recognize same-sex and interracial marriages from other jurisdictions. So that's going to become important in a minute. But essentially, Respect for Marriage Act says that if another state calls it a marriage, you have to call it a marriage too. So the other thing to know right before I change my slides is that between 2020 and 2024, there have been 4 states so far that have repealed their bans. And those are Nevada, California, Colorado, and Hawaii. So we are looking to join the ranks of those and other states that are now looking to remove their own bans for same-sex marriage. So the current situation, so I wanted to, we saw some lovely maps, and you can see that the map here follows that same pattern, right? That same southern pattern that we tend to see in a lot of different maps. I'm an epidemiologist by training, and we see them in infectious disease maps as well. But this is the support for same-sex marriage by state, and the main takeaway I want to say here is that no state is, in this particular poll, no state was under 50%. So every state in the union on this poll said that the majority of folks are supportive of same-sex marriage. In Virginia, it was 68%. So you can see we're kind of blue in that picture. So 68% of Virginians polled supported supported marriage equality. There are a couple other maps in this report. One indicates that 13% of Virginians identified as LGBTQ in the poll. So in our world, we often use that sort of 10%. I'm sure some folks have heard that 10% of folks would be in the community. This poll showed 13% and much higher in the younger community that may feel more comfortable coming out and expressing their gender and sexual orientation preferences. The other thing that I thought was really interesting is that there's another map about supporting laws protecting LGBTQ plus people from discrimination that show that 75% of Virginians are in support of that. So really a very different look than what I pretend was 10 years ago, but was really 30. A very different time. So our current situation in terms of this amendment is that the amendment that bans same-sex marriage in Virginia is what's called a zombie amendment. It's there, it's inactive, it can't function because Obergefell says that it's illegal. However, that is the only protection in Virginia for same-sex marriage because while the RFMA, I'll keep jumping back and forth, sorry. The Respect for Marriage Act in 2022 says that you must recognize other jurisdictions' marriages. It doesn't say that you have to officiate them yourself. So if Obergefell were to fall, the amendment would kick back in and Virginia would have the option not to do same-sex marriages. Sorry, okay. There was something I wanted to say, I'm trying to remember the exact language of it. The thing that people kind of think this is settled, like, oh, Obergefell, it's fine, don't worry about it. But in the Dobbs decision that overturned Roe v. Wade, Justice Thomas made several remarks about other things that he would like to see revisited, and Obergefell was one of them. So it's not unheard of that this might go back to the Supreme Court to remove Obergefell from our, I don't know, I'm not a lawyer. Jurisprudence, is that a thing? I don't Sorry. A little out of my wheelhouse on the actual legal. So that's why we have an amendment this go around. I'll show you this, although this is what we've already talked about, the fact that it has to go through twice with an intervening election. What I think is interesting here, these are, without getting too in the weeds, the 2 votes in 2025 and 2026. You can see it, the House of Delegates and then the State Senate. And while it's nice to see from my perspective that all the Democrats are voting in favor of this amendment, you can also see that there are Republicans on board. So I wouldn't necessarily say this shows bipartisanship, but it certainly shows more than we've ever seen before. So I think that's important to keep in mind as well, is that the more people who know people, the more people realize that they love someone who. So this is the text of the amendment. It does three things. Say it correctly. The first part is remove the ban on same-sex marriage, so that's the repeal part. It strikes the one man, one woman language from the Bill of Rights, section 15A, where it currently sits. Number two, affirm that two adults may marry regardless of sex, gender, or race, so it establishes marriage as a fundamental right, and it ties interracial marriage into the mix as well. And three, it require all legally valid marriages to be treated equally under the law. So it requires the Commonwealth to recognize and treat all marriages, regardless of sex, gender, and race, as equally valid marriages. And I just wanted to shout out that that's an official Virginia Tourism Board logo for Virginia. That's not, I didn't make that up. That is in 2020, what year was it? I wrote it down. They came out with the logo in 2016. They came out with the logo with just the rainbow. And then in 2021, that's what we call the progress flag, because it has the trans flag and black and brown interracial, the connection of all of us in one flag. And this was updated in 2021, so you can find both of them. But it's, again, becoming mainstream, I guess is a word we could use. So as we saw by those percentages, much more acceptance in this world. And then our call to action, I think similar to some of the other things that we talked about, we want to really make that move from something that is court ordered to actually voter affirmed. A lot of folks think that this is settled law because of Obergefell and don't necessarily realize, maybe more so since the Downs decision, but may not otherwise realize how perilous some of these things are. So the call to action, obviously vote in November, but also educate, share what you've heard, share, do your research and share what you learn. One thing I wanted to, because a lot of times folks say like, well, how, it seems, I don't know, not everyone may be in agreement, but it's a relatively simple argument to make, but folks often then run into challenges. And one of the things that I thought, I just want to wrap up with this, that I thought was really interesting, and I remember when this happened in 2020, there was a case before the Supreme Court, Bostock v. Clinton County, Georgia, and it was about protections from being fired for being LGBTQ. And so in 2020, when that was decided, Justice Roberts and Gorsuch joined the liberal justices in saying that you cannot discriminate, harkening back to the 1964 Civil Rights Act. And it was actually Gorsuch who wrote the majority opinion, which is unusual on a case like this. There's a lot unusual about this case, but what Gorsuch wrote, and I thought this is something that I sunk into my brain and I keep it there for reference. It's impossible to discriminate against a person for being homosexual or transgender without discriminating based on sex. And he then gave the example, if you have two employees, a man and a woman, and they're both attracted to men, so you have a man attracted to a man and a woman attracted to a man, and you fire the man who's attracted to the man, the only difference between those two situations is their gender or sex. So therefore, you are doing sex discrimination, which is explicitly illegal in all the previous cases. So I thought if you have someone who's sort of a textualist, is that the right word for folks who, okay, thank you, policy folks. If you have someone who really goes by the word of the law, even the word of the law supports a lot of these arguments. So I just thought that was an interesting thing to share. And this vote really is about creating permanence and safety for thousands of Virginia families, folks who've been marginalized through the years and have finally seen themselves more so in our society, making space for them and enshrining their safety into our law. That's it for me. Thank you.
So great. Thank you so much to our speakers. That was tremendous and very informative. We are in a good situation with the time. Our target time to end is 8:30. So I want to get to as many questions as possible, and to make sure that our speakers can understand them, I'm going to travel with the microphone. And I'm going to go first to the woman who was so patient, and when I squashed her earlier. I appreciate it, so thank you.
So my question that I wanted to ask was, I know there was a ruling that just came out regarding returning citizens' ability to register to vote and to go vote.
Yes.
So why do we need to vote on this amendment if that's already been approved?
Thank you for the question.
I'm sorry, could I ask you to repeat the question? I'm very lost, so.
She's asking about the
Yes. There was a very interesting lawsuit in which, was it the NAACP? I believe, yes, sued with some other plaintiffs, arguing that the state of Virginia, the Commonwealth, had not adhered to the felonies at common law that were named in the Virginia Readmission Act. And so Virginia was in fact in defiance and not in compliance with that act. And believe it or not, the court agreed. So that leaves us in a very interesting position where we have an awful lot of people who are in prison for felony drug offenses, which were not felonies of common law. And the question is, are those people automatically restored their right to vote because they were disenfranchised in violation of an 1870 statute? And how do you go, and if that is true, how do you go about registering those people to vote while they're still in prison?
So they just announced that that was supposed to, the correction for that was supposed to take effect as of, the decision was originally, came out in January, I believe, and they had till May 1st to rectify this. Meaning all these folks that are convicted of a felony drug possession, which was another way to, in a discriminatory fashion, ramp up the number of African Americans who were excluded from the right to vote, potentially permanently. But so these are folks who are currently incarcerated and theoretically, based on this decision, now will have the right to vote. But because of the complexity of trying to determine, okay, what's your conviction for? Do you get your right to vote back? How do we find those folks? How do we let them know that they're eligible to vote? Will they be actually able to vote while they're still incarcerated? Something that has not happened for felonies in Virginia in the past. That's such a complex thing to work out that they've now postponed it till at least June 1st. And it would not surprise me at all if it gets postponed even further. And the thinking being that once this amendment gets passed, then basically all of that goes away. But I have not yet seen addressed, and the lawyers may know this better, and Lisa's the lawyer, is if people, right now, if you have a misdemeanor, you're incarcerated, you do not lose your right to vote. So we go into the Fairfax Detention Center and we register and make sure people get their absentee ballots so they can vote while they're incarcerated if you have a misdemeanor. If we're now saying there are classes of felonies that do not disenfranchise you, presumably we will also be able to register those folks so that they can vote. But there's going to be a huge public education campaign, and not just public, because the correctional facility staff is going to have to understand that, and you know, institutions being relatively resistant to change, particularly a radical change like this, I expect is going to be really a while to work out those details. But good for you for picking up on the hot button news item. That's excellent.
Who's next? Who's next? I'll switch up here and I'll come back to you.
Sure, okay. If we pass the, abortion rights thing and the federal government decides to do a federal law, does that disenfranchise our state law?
Yeah, that's a great question. So, yes, if there was a federal abortion ban, that would override our state law. What our state law would, what a state constitution would do would be to ensure that Virginia politicians coming in, as they tried to do in 2023 when they campaigned on an abortion ban, they will not be able to pass an abortion ban in Virginia without, and I know we spent some time, one of the things we talk about a lot, this process took us forever. And that's really not an exaggeration. I'm sure a lot of people in here have been fighting with us the whole time. I started at Planned Parenthood Advocates of Virginia with the goal of getting this done in 2021. For context, I'm very tired. But I say that to say that one of the things we like about the constitutional amendment here in Virginia is it is hard. We don't collect signatures like they do in so many states, which is very expensive, fun fact, but is something that anyone can do. We are confident that any effort to undermine this constitutional amendment from within the state would be unsuccessful. The reason we feel that way is because a bunch of people would have to go on the record and say, I really want to ban abortion, so we should repeal this constitutional amendment. And let me just tell you, firsthand, I worked on a lot of these elections, politicians saying that they want to ban abortion isn't going great for them in Virginia. Kind of uniformly, I don't know if you remember up in Northern Virginia in 2023 when Stirrup was running against now Delegate Josh Thomas, and he got caught saying that he wanted to pass a 100% abortion ban, and I think that guy's campaign basically ended at that moment. It's just such a wildly unpopular position that their chances of being able to get reelected to a majority that would be able to do it for the second time and then get it on the ballot and get Virginians to vote to lose a right feels incredibly unlikely. You're right that the federal pieces can still impact us. There's always going to be more work to do on this. That's why one of our big goals here is we don't just want to win this amendment. I think we will, is of course our major goal, but we don't just want to win. And that's why you hear me talking a lot about sharing stories and talking to family and friends. We need a groundswell of passion and energy. And the really great thing about this is I can tell you, I've been so excited by the young people who are incredibly, incredibly excited about this issue. We've had dozens of college students come out to lobby at legislative session, take off of school and come to Richmond to talk about this issue. We need to make long-term cultural change, not just here in Virginia, but across the country, to protect our reproductive freedom and remind people that this is healthcare. And when you mess with our healthcare, you mess with our lives. We've seen what's happening across the South where bans are. We've watched people die. Disproportionately women of color, I'd like to point out also. So you're right, it's not over. And when we pass this amendment, it won't be over. The fight is not going to just end in Virginia, but it's a big step. And it will protect the last state in the South without a post-roe abortion ban.
Thank you, Monica. I see another hand.
Yeah, you've mentioned more than once people are dying. Is somebody killing them?
Kind of. So right now, people are dying because they need access to health care. Women are dying because they are unable to receive health care while having a miscarriage. They're going septic, they are bleeding out, and they are dying as a result of these abortion bans. In fact, departments of health have directly cited these abortion bans as causes of death for many of these women.
I'm still confused. They're having miscarriages naturally and
Yes.
they're dying from it?
Yes.
And this could have been prevented had they had an abortion earlier?
Miscarriage management is part of our protection in the amendment. One of the big problems is that the difference between miscarriage management and an abortion are not defined in law. So what we are actually seeing happening in real time is a woman is having a miscarriage. She goes to the doctor. She's bleeding. She says, I need health care. And the doctors go, great, let me go talk to a bunch of lawyers about if the politicians will let us do this. So women are actually dying while waiting for health care to be decided.
So they're bleeding out, in other words.
bleeding out is one thing. Going septic is actually the most common thing. Sepsis is an infection of the blood, which can happen if you have necrotic tissue inside of you. That's not good for you, and the medications that are used to treat a lot of these miscarriages are identical to abortions. And in fact, it's worth pointing out, you cannot tell if someone is having a miscarriage or if they had an abortion. There's not a medical difference. In fact, spontaneous abortion is another word for miscarriage.
I have one more question regarding
Could you hold the microphone?
I'm sorry.
Yeah, that's
sorry. So I have one more question regarding the amendment, particularly the last part, where there seems to be a restriction in the third trimester, and I am confused. Now there seems to be an exception to, like 2 exceptions, but I'm not understanding why there is any restriction whatsoever. Don't you feel strongly that abortion should be available at any time for any reason or for no reason?
I feel strongly that abortion is healthcare and that people should be able to make the decisions that are best for them with their healthcare providers. This amendment was passed by the legislature. We did not write this amendment, but we are passionately in favor of it. The reason the legislators decided to put a limitation on abortion in the third trimester into that constitutional amendment. So that is written in there, the 2 exceptions again, and we do feel that this will stop people from dying from this or being forced, as we saw in many states. I don't know if you all followed the Montana cases of people who were being forced to give birth to children that had no chances of survival, that people have talked about a lot. Our amendment would allow for a person in the third trimester to receive abortion care if it is for their health, because we know pregnancy is complicated, it's unique, and it's dangerous. The maternal mortality rate is still very high, and it's incredibly high for Black women in particular in Virginia and across the nation. So we believe that because there is the ability to access care in these extreme situations where someone's health is at risk, or when there is a fetal diagnosis, I can name some of the most extreme ones, but there are things like spina bifida and anencephaly, where a fetus can develop without a brain or without a proper working spine, and all of these things are not compatible with life. So we feel confident that with those protections, people who need an abortion even later in pregnancy will not be forced to go through something physically or emotionally potentially deadly.
Well, I just want to clarify, and then I'll pass on the microphone. Why is it that the legislators put in this restriction whatsoever? I mean, it has its exceptions, but why was there a restriction whatsoever?
I really can't answer I can't tell you every legislator's individual reasons. I will say that the anti-abortion extremist movement has been incredibly successful at talking about abortion up until birth, a thing we know does not exist and cannot exist and is not how medicine works and could not exist under this amendment. So if I had to take a guess at why the legislators wrote the language exactly the way they did, I would say that it was probably in response to those anti-abortion misinformation pieces.
It follows Roe versus Wade too, which was successful for 50 years, right?
So ours is a little different than Roe v. Wade. It more tracks to current Virginia law than Roe v. Wade. We are on a trimester system, so we have protections through the first trimesters. Roe v. Wade is not on a trimester system. So it's similar, it's just a little medically different. We used, Roe v. Wade does not use medical terminology around trimesters. This amendment does.
Thank you. I'm going back to this lovely woman.
So I have 2 questions. One is on the reproductive freedom. I know it says, or it's around your fertility and your childbearing timeframes, but does birth control also impact hormonal regimen, or could it impact for hormones in general? I'm not in my childbearing years, and didn't know if psychotherapy
So
be impacted?
not by this amendment. This amendment does list specific care. No, I don't want to, there are trans people who use birth control, right? For all types of reasons. This does protect the right to birth control.
Or menopausal?
Sorry, say that again?
Menopausal or postmenopausal?
Yeah, if you're using birth control for that, that would also be protected, because the access to birth control is protected. Our amendment does not contain protections for gender-affirming care. So in the ways that some people may use birth control as gender-affirming care, they would have access to that birth control.
Okay. And then my second question is, for the same-sex marriage, what are the federal benefits that are impacted by not voting yes for this amendment?
Great question. So again, not a lawyer, so I might hand it off, but I think we're talking about, if there are survivor benefits. So if your partner has a federal pension or, Social Security benefits, things like that, anything that you would inherit. Am I using the words right? Yeah. Okay. So it basically protects anything that the feds award a spouse. That's what the change in the law at that time was kind of affirming that the feds would allow that as part of same-sex marriage, but only that. So that doesn't affect anything else.
So are there state benefits that people would be able to get?
I don't know the answer to that. I would assume so.
I think that they're already able to access them now on the basis of the current, I'm not an expert on this amendment, but I will say, I believe that those protections should already be legally protected as the marriage is fully recognized in Virginia. My understanding is that this is more about stopping that from not being the case.
Yes, that's exactly right. So Obergefell, when that went into place in, 2014, thank you, 2015, made it all legal. So all marriages are treated the same currently. The reason for the amendment is, should the Supreme Court toss Obergefell, then our old law kicks back in. Thank you.
Anyone else have a question?
Anyone else have a question? Gentleman in the back.
Yeah, I need to understand your logic in the case of this restoring the vote to people. If I don't want a person that rapes women or kills children or does any other heinous act to vote, I really don't care what race they are. I don't understand why that would be a factor. The mere fact that more people in a particular race prefer to commit a particular type of crime has no bearing on whether I want a person that committed that crime to vote or not. Even if 100% of the people that committed a crime that I didn't want people to vote after they did were black, that wouldn't mean that I would want them to vote all of a sudden. Why should those two things have any bearing on each other? If I don't want somebody that kills somebody to vote, it doesn't matter what race they are. Why should it?
People who are incarcerated, regardless of the crime they commit, continue to be citizens, if they are in fact citizens of the United States and citizens of Virginia. They might still be liable for taxes if they have income. They have certain features of being citizens. They do not lose that by virtue of the fact that they go to a prison or a jail. So,
Well, do you believe they lose the right to own a gun?
well, the right to own a gun is in fact, can be judicially taken away, and almost always is. This particular amendment has nothing to do with right to own a gun. This is only voting rights.
It's in the Constitution just the same as the right to vote.
Just a moment, please. The rights that a governor can restore today do not include restoration of the right to own a gun. The rights are the right to vote, the right to serve on a jury, and the right to be a notary, and to hold public office or run for public office. The right to own a gun can only be restored by a court, and this amendment does not affect that.
We didn't begin to answer my question. Why should the race of the person affect whether they're still allowed to vote or not? I mean, why should the person's right to vote depend upon the race of the people that technically?
Sir, just to answer your question, it does not. We wanted to just make sure that people understood how we got to where we are with the law in the state of Virginia. As we said, every state is allowed to make its own decision about restoring voting rights, and every state does it slightly differently. But Virginia and some of the other southern states, it was written specifically to try to make it harder for minorities to be able to vote. We are simply just filling in that historical context so you understand. We believe that the amendment is not going to restore rights to any particular race who've been affected by this. It's for everyone who's so affected. Male, female, black, white, Latino, it doesn't matter. We're just saying that this will correct. We tell people.
You can't have it both ways. Either you're correcting for some racial bias that you think existed, or you're concerned about the rights of the person. You can't. I think you're doing this for the other reason, not the legitimate reason.
May I interject? I had a friend who was murdered, and I always felt that if they go to jail, lose their right to vote. They cannot think properly. But if that person serves their time and comes out of jail, that means the courts and the people have decided that they were eligible to re-enter society, in which case they have the right to vote.
I would add another small sort of footnote to this, which is that if someone is sentenced, the sentence might include jail time, it might include payment of some fees and fines, it might include restitution paid to the victim or the victim's family. Those things don't go away. Those obligations remain. It is simply that the person's right to vote and other rights are restored upon release. It doesn't dispose of the need for parole or any of those things in addition. They remain.
If you won't defend their right to own a gun, you shouldn't defend their right to vote. It's equally valid to take.
Well, sir, that's not on the table for us tonight.
I'm on the table. I'm saying if you know you wouldn't defend the one, so you shouldn't defend the other if you won't defend the one.
I don't think this is going to be a productive discussion on this, because again, this panel was here to specifically talk about these particular amendments, okay? So I appreciate your...
All right, I said what I needed to say.
Okay, very good. Thank you. One last question then from you, please.
It's not a question. It's not a question. This is why you have a right to either vote yes or no based on the position that you have. So go out and exercise your right to vote.
Thank you. And that's exactly right, and that's what all of us who are involved with the League of Women Voters are passionate about, is making sure that people exercise their franchise, that people know and get informed about the issues so they can make the best possible decision when they go to the ballot box. So thank you all so much. Thank you for our panel. Please, if you'd like to take any information about library programming, the League of Women Voters, or any of our great panelists, please do so. Thank you for coming.